Look at me. Look at me. I am the host of Media Watch Now. This is a very short introduction about defaming the dead. Over the past fortnight, public debate has largely been preoccupied with the question of how to respond legally, morally, socially, whatever, to the allegations raised against the Attorney General, Christian Porter. Importantly for this video, the allegations were made by a woman who is now deceased, with the government not commissioning an independent inquiry into the allegations. The press has been fixated with the idea of the court of public opinion. Unlike a real court, the court of public opinion has very few rules about what evidence is admissible and how that evidence can be used. In fact, there are generally two sources of rules. The first is media regulation. There's self-regulation, like the Australian Press Council, which is there, funded by print media to promote good practice amongst member institutions. And then there are statutory bodies, like the ACMA. If you read a paper lately or watch the news on television, you might suspect the rules imposed, to whatever extent, by media regulation were a bit flimsy. You would be correct. We now have had several decades of discussion about how to improve media regulation in Australia, with no obvious signs of things improving. The second source of rules comes from an area of law known as tort. It's the law of private injuries. If somebody hits you and you sue them, you've entered the wild and wonderful land of tort. The most important tort for media regulation is defamation law. It's the law that, to whatever extent possible, prevents media companies from making a profit from injuring your reputation. High-profile cases in the media have soured somewhat, coloured public debate about the law of defamation. Here, on the other hand, is the Wagner family. Two media outlets quite shamefully accused them of being responsible for the Grantham floods, without having the slightest evidence to support their claims. In fact, they even had evidence to say that it wasn't true. Without formal media regulation to give the wider public reassurance that the news is fair and accurate, defamation law acts as an informal form of regulation. And this gets us back to the Attorney General. Because the government hasn't commissioned an inquiry, media companies are attempting to uncover more details to inform public debate. Should we believe the claims? What about the presumption of innocence? What about the rule of law, however vaguely defined? What about this play from the 1960s about St. Thomas More, you sewer rats? Of particular note was a story that circulated that called into question the reliability of the complainant's case. Did recovered memories target Christian Porter? The idea is that the complainant was unreliable for psychological reasons. Of course, as the complainant is deceased, there was no way for the journalist to undertake a clinical examination of the complainant's psychological state. But it was popular with the centrist old guy demographic on Twitter. My point here is not to prosecute the question of repressed memories, but instead to draw attention to why media companies are willing to publish this sort of noise to the detriment of one party, but not to the detriment of the other. Of course, there's the baked-in misogyny. Discrediting women about their experiences of violence has a long and ignoble tradition. But there's also a legal reason. In nearly all jurisdictions, but not New Tasmania, there is no cause of action for defamation of or against the deceased. When you die, people are permitted to say the most insanely buckwild shit about you, and you cannot even sue them. Or rather, your family cannot sue on your behalf. If you're dead, it is open season. The Attorney General, who is very much alive, can sue for defamation. In the court of public opinion, we are left without defamation law acting as an we are left without defamation law, and this acts as an uneven playing field. For one party, nearly everything is admissible, every rumour, every indiscretion, every flaw. For the other, defamation law sets a higher bar. Now, If this were that other version of Media Watch, the argument would very likely be this clearly shows that the defamation law bar is too high. It is protecting somebody that journalists have juicy rumours about but cannot prove. But isn't this actually an example of the opposite? Why should it be acceptable for media companies to smear a claimant in this way, even if she is dead? What is the public good here? What is the public benefit? Isn't this actually a good example of why we need stricter media regulation in Australia? This was all a bit of a test. Let me know if this new format works. You can argue with me on Twitter @LegalReckoning. Until next time, bye.